For decades, government officials were aware of toxic water contamination at the United States Marine Corps base Camp Lejeune in North Carolina, but those in power ignored the issue and denied victims their right to seek justice. Between August 1st, 1953 and December 31st, 1987, service members and their families stationed at Camp Lejeune consumed and bathed in water that contained high levels of toxic chemicals. Most of these individuals have gone on to experience severe health issues as a consequence of the exposure. On May 30th, 2022, a new bill was passed that allows veterans to seek long-denied justice, the Camp Lejeune Justice Act. This allows injured Marines and their families to finally be able to seek justice for exposure to toxic water at Camp Lejeune between 1953 and 1987. Runoff from storage tanks, treatment plants, and a nearby dry cleaner put trichloroethylene, or TCE, perchloroethylene, or PCE, benzene, and vinyl chloride into the camp's water supply. All these harmful chemicals are classified by federal agencies as causes of cancer and other deadly diseases. Veterans and their families began filing suits against the U.S. government in 2005, alleging harm from exposure to contaminated drinking water. In 2016, all claims were dismissed. The court determined that such claims were barred by both federal and North Carolina law. Under the Ferris Doctrine, service members may not sue the U.S. government for injuries incurred incident to military service. Under the North Carolina Statute of Repose, a plaintiff is barred from bringing a suit for more than 10 years after the contamination occurs. Camp Lejeune water contamination has been linked to the serious health issues of veterans and their families, including the following: aplastic anemia, birth defects, bladder cancer, brain cancer, breast cancer, cardiac defect, cervical cancer, dental issues, end-stage renal disease, epilepsy, esophageal cancer, female infertility, hepatic steatosis or fatty liver disease, Hodgkin's disease, intestinal cancer, kidney disease, leukemia, liver cancer, lung cancer, miscarriage or fetal death, multiple myeloma, myelodysplastic syndromes, neurobehavioral defects, non-Hodgkin's lymphoma, pancreatic cancer, Parkinson's disease, prostate cancer, renal toxicity, and scleroderma. To qualify for disability compensation, you must provide evidence for three things: a current disability, an in-service injury or illness, and a link between the in-service injury or illness and the current disability. Under the Veterans Affairs rules regarding Camp Lejeune water contamination, veterans with certain service experience don't need to prove an in-service injury or illness the same way as they would for other claims. Instead, the exposure to contaminated water is presumed if the veteran received a discharge under conditions other than dishonorable from active duty, reserve, or National Guard service, and served at Camp Lejeune or MCAS New River for a total of at least 30 days between August 1st, 1953 and December 31st, 1987. If you're uncertain if you qualify for compensation based upon the above criteria, fill out a contact form and send us a message to see if one of the law firms in the Law Center network can help you. Find the link for the contact form in the description portion of this video.